love.
Good afternoon, everyone. I'm Liezel Schultz. I'm an attorney and property law specialist with Goldman Schultz Attorneys. This afternoon, I'm coming to you from the beautiful Natal Midlands. I'm busy making my way up to Gauteng from Durban to spend a weekend with family, and I thought what better time to do a quick video and give you some information. So the topic of my video this afternoon may be quite helpful to anyone who is presently co-owning property with other co-owners. And specifically, I'm going to be telling you or advising you how you can end that co-ownership and what our law provides and what may be of assistance to you. So in terms of South African law, our law recognizes that no one should be trapped in a co-ownership situation. So there is remedies that we have historically taken over from Roman law that provides you with the remedy to approach the High Court for assistance when you are at the point where you need to end the co-ownership insofar as the property is concerned. And the legal or Latin term for that application or that remedy or that action is called the actio communo dividundo. Long Latin term, but it comes all the way from Roman law. Now, firstly, I want to just explain these two different types of co-ownership that exist in terms of our law. The one is what we call bound co-ownership, and the other one is free co-ownership. Now, free co-ownership is a situation where the only legal relationship that exists between the parties are their co-ownership of the property, and they can end that relationship at any time if they agree to do so. The bound co-ownership is where there's another legal relationship that underpins the co-ownership of the property. And examples of that is, for instance, parties married into property. And when you marry into property, you own all the property jointly with your partner. And there I also want to advise everybody that if you own the property and the title deed only has your name on it, and you subsequently get married into property, your spouse, by virtue of the law, is now a co-owner of that property, even in the case where their name does not appear on the title deed. The mere marriage makes that co-ownership come into existence. So whether or not the party's name is on the title deed does not necessarily prove that they are or are not co-owners. In the case of marriages into property, the marriage makes that co-ownership come into operation. So when it comes to bound co-ownership, it's a little bit more difficult to cancel that co-ownership or to extract yourself from that co-ownership than it is with free co-ownership. And free co-ownership, mostly the reasons for free co-ownership, in my opinion, is financial, where parties financially needs to put their funds together to own a property, and also often because of inheritances. So you, with your family or other heirs, inherited a property and you all now own it jointly. Now, in terms of the remedy that I've mentioned that we inherited from Roman law, the only way that you can actually end or extract yourself from co-ownership is either the parties or the co-owners agree to end the relationship, and that would be by selling the property. So there would be an agreement reached between all co-owners to sell the property, or they would agree to transfer their shares or his or her share to the other co-owner, and they'd agree on the compensation for that. But if there's no agreement, and if there cannot be an agreement reached between the co-owners, the only remedy that you have is this Roman law, and that action is an application that you'll bring to the High Court to ask for assistance to end the co-ownership. And the courts will generally assist with that, because in terms of our law, we have the principle that you cannot be forced to remain in a co-ownership situation when you don't want to be in it. And the courts would look at the circumstances and provide a remedy that is just and equitable in the circumstances. So if you are stuck in a situation of co-ownership on a property and you cannot agree with the co-owners for the property to be sold or for the other co-owners to take over your share and pay you for that, your only remedy in order to extricate yourself would be to approach the High Court. Now, you cannot sell, or it is virtually impossible or very difficult to sell your undivided share in a property to somebody else. Most people would not want to become a co-owner of a property with people that they don't know. What would happen in the circumstances, the court would, in most cases, give an order for the property either to be sold by public auction or by private treaty, and the court may also make an order as to how the sale proceeds are to be divided between the co-owners. And if there cannot be an order reached or an agreement reached regarding the split of the sale proceeds, the court may also appoint a liquidator to liquidate the assets or asset and to distribute the proceeds in a way that's just and equitable. So that's the long and short of co-ownership of property. And if you do need any assistance in that regard, you are more than welcome to give me or my partner a call at our office, and we will certainly see where and how we can assist. Again, my email address is Liezel, Liezel @gslaw.co.za. On that note, bid you a good end to the week, and I will chat to you again in about a month's time. Thank you very much.